Welcome to episode 30 of the Supreme Court Opinions Read podcast, where we read Supreme Court opinions so you don't have to. My name's Bailey, and I'll be reading the Supreme Court's opinion in Mirabelli v. Bonta. The case was decided March 2nd, 2026. And there is no syllabus, so we will move right on to the opinion, which was written per curiam. Before us is an application to vacate a Court of Appeals order staying a permanent injunction entered by a district court on behalf of parents and teachers who claim that certain California policies violate their rights under the Free Exercise Clause of the First Amendment and the Due Process Clause of the 14th Amendment. The parents object that these policies prevent schools from telling them about their children's efforts to engage in gender transitioning at school unless the children consent to parental notification. The parents also take issue with California's requirement that schools use children's preferred names and pronouns regardless of their parents' wishes. The teachers object to their compelled participation in the implementation of the state's policies. Part 1. This case began in the United States District Court for the Southern District of California in 2023 when two teachers sued seeking an exemption from their school district's policies regarding students' gender. During litigation, the school district claimed that state law, as interpreted by the California Attorney General and the Department of Education, required it to adopt these policies, so the teachers added state officials as defendants, and parents of California school children joined the lawsuit as plaintiffs. Relying on their own experiences and guidance documents issued by state officials, plaintiffs alleged that California's policies permitted disclosure of a student's gender transitioning at school only if the student consented. Plaintiffs claimed that these policies violated their rights under the Free Exercise Clause of the First Amendment and the Due Process Clause of the 14th Amendment. Two of the parent plaintiffs, John and Jane Poe, have religious objections to gender transitioning but were not told by their daughter's school when she began to present as a boy and use a male name and male pronouns during her 7th grade year. In parent-teacher meetings, no one told the Poes about their daughter's transitioning or referred to her using the male name and pronouns that were used at school. At the beginning of their daughter's 8th grade year, she attempted suicide and was hospitalized. Only then did her parents learn from a doctor that she had gender dysphoria and had been presenting as a boy at school. Just months after being discharged, the Poe's daughter was re-hospitalized and held there involuntarily because she was at risk for self-harm. At a new school in 9th grade, she once again began identifying as a boy. Contrary to the Poe's instructions, teachers and school officials continued to use a male name and pronouns for their daughter, citing their obligations under California state law. The Poes have placed their daughter in therapy and obtained psychiatric care for her. Like the Poes, plaintiffs John and Jane Doe object to gender transitioning, but since 5th grade, their daughter has sometimes identified as a boy. When their daughter was in 7th grade, the Does confronted the school principal about their daughter's transitioning. They believed the school was using a male name and pronouns for their daughter behind their backs. The principal explained that state law prohibited the school from sharing information about a child's transitioning with the child's parents without the child's consent. The Does believed that the risk of leaving their daughter in that school was too great, so they transferred their daughter to a new public school because sending her to a private school was financially and logistically infeasible. The Does have also placed their daughter in therapy. In 2025, defendants asserted that the guidance documents on which plaintiffs had relied were no longer operative and that the claims against certain state defendants should be dismissed as moot. But the state had promulgated a new required training curriculum that similarly directed teachers not to tell parents about their children's gender identity without the children's consent. Defendants then withdrew their mootness argument and the district court declined to impose sanctions. Later, plaintiffs sought class-wide relief and the district court certified a class with separate subclasses for parents and teachers. One subclass of parents comprises all those who object to the challenge policies, while a separate subclass is limited to those who seek a religious exemption. Two similar subclasses of teachers were also certified. After discovery, the court granted summary judgment for all plaintiffs and entered a permanent injunction in their favor. The injunction prevents the schools from misleading parents about their children's presentation at school and their social transitioning efforts. It also requires the schools to follow parent directions regarding their children's names and pronouns, and it compels defendants to include in state-created or approved instructional materials a notice of the rights protected by the injunction. The Ninth Circuit granted defendants' motion to stay the injunction pending appeal. It began by raising procedural objections to the district court's injunction. It claimed that the district court had granted class certification without undertaking the rigorous analysis required by Federal Rule of Civil Procedure 23, and it stated that the injunction appeared to be overly broad because it covers every parent of California's millions of public school students and every public school employee in the state. As a result, it opined the injunction seemed to grant relief to uninjured class members who lacked Article 3 standing. The Ninth Circuit also expressed doubts about the district court's decision on the merits. On the free exercise issue, it relied on a not presidential Sixth Circuit decision and brushed aside Mahmoud v. Taylor as a narrow decision focused on uniquely coercive curricular requirements. The Ninth Circuit expressed skepticism about the parents' and teachers' 14th Amendment due process claim because it viewed those claims as seeking to expand the protection afforded by established precedent. When the Ninth Circuit stayed the injunction, the parents and teachers filed this application seeking vacatur of the Ninth Circuit's stay pending appeal. Part 2. We grant the application and vacate the stay with respect to the parents because this aspect of the stay is not justified under the governing four-factor test. Likelihood of success on the merits. We conclude that the parents who seek religious exemptions are likely to succeed on the merits of their Free Exercise Clause claim. California's policies likely trigger strict scrutiny under that provision because they substantially interfere with the right of parents to guide the religious development of their children. The parents who assert a free exercise claim have sincere religious beliefs about sex and gender, and they feel a religious obligation to raise their children in accordance with those beliefs. California's policies violate those beliefs and impose the kind of burden on religious exercise that Yonder found unacceptable. Indeed, the intrusion on parents' free exercise rights here, uncontested facilitation of a child's gender transition, is greater than the introduction of LGBTQ storybooks we considered sufficient to trigger strict scrutiny in Mahmoud. California's policies will likely not survive the strict scrutiny that Mahmoud demands. The state argues that its policies advance a compelling interest in student safety and privacy, but those policies cut against the primary protectors of children's best interests, their parents. California's policies also appear to fail the narrow tailoring requirement. The state's interest in safety could be served by a policy that allows religious exemptions while precluding gender identity disclosure to parents who would engage in abuse. For these reasons, the parents who object to the California policies on free exercise grounds are likely to succeed on the merits. The same is true for the subclass of parents who object to those policies on due process grounds. Under long-established precedent, parents, not the state, have primary authority with respect to the upbringing and education of children. The right protected by these precedents includes the right not to be shut out of participation in decisions regarding their children's mental health. Gender dysphoria is a condition that has an important bearing on a child's mental health, but when a child exhibits symptoms of gender dysphoria at school, California's policies conceal that information from parents and facilitate a degree of gender transition during school hours. These policies likely violate parents' rights to direct the upbringing and education of their children. Irreparable harm. The denial of plaintiffs' constitutional rights during the potentially protracted appellate process constitutes irreparable harm. Balance of equities. Finally, the equities do not justify depriving the parents of the district court's judgment in their favor. Everyone agrees that children's safety is the overriding equity, and the injunction here promotes child safety by guaranteeing fit parents a role in some of the most consequential decisions in their children's lives. The injunction also permits the state to shield children from the unfit parents by enforcing child abuse laws and removing children from parental custody in appropriate cases. Part 3. The Ninth Circuit's procedural objections to the injunction are unlikely to prevail. First, the parents protected by the injunction very likely have standing because they are objects of the challenged exclusion policies. Contrary to the Ninth Circuit's suggestion, the injunction does not provide relief for all the parents of California public school students, but only for those parents who object to the challenged policies or seek religious exemptions. Second, class certification was likely proper. The district court addressed the requirements for certification under Rule 23 and explained why it concluded that they were met. The application to vacate the Ninth Circuit's stay presented to Justice Kagan and by her referred to the court is granted as to the parents but is otherwise denied. Justice Thomas and Justice Alito would grant the application in full. Justice Sotomayor would deny the application in full. Justice Barrett, with whom the Chief Justice and Justice Kavanaugh join concurring. As the dissent observes, substantive due process is a controversial doctrine. Judges typically interpret express constitutional rights such as the freedom of speech or religion. But substantive due process asks us to find unexpressed rights in a constitutional provision that guarantees only process before a person is deprived of life, liberty, or property. When rights are unstated, how do judges know what they are? The obvious risk is that judges will use their own values as a guide, thereby jeopardizing the people's right to self-governance. To mitigate this risk, the court has crafted a demanding test for recognizing unexpressed rights. They must be deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. Relevant here, the doctrine of substantive due process has long embraced a parent's right to raise her child, which includes the right to participate in significant decisions about her child's mental health. The parent applicants are likely to succeed on the merits under a straightforward application of these cases. California prohibits its public schools from informing parents of their child's gender transition at school unless the child consents. The record in this case indicates that the state's non-disclosure policy applies even if parents expressly ask for information about their child's gender identification. One set of parents learned of their child's transition at school only after the child attempted suicide. Strikingly, even after this tragic event, school administrators continued to withhold information about the student's gender identification. California's non-disclosure policy thus quite obviously excludes parents from highly important decisions about their child's mental health, and is unlikely to satisfy heightened scrutiny. Our resolution of the parent's likelihood of success on this claim is dictated by existing law. The dissent questions how the court can adhere to parental rights precedent after its decision in Dobbs v. Jackson Women's Health Organization. But Dobbs calls into question neither the doctrine of substantive due process nor the other unexpressed rights that the doctrine protects. Applying Glucksberg, Dobbs holds that Roe v. Wade and Planned Parenthood of Southeastern Pennsylvania v. Casey were incorrectly decided because a right to abortion is not deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. And because the court concluded that the stare decisis factors counseled against retaining these cases, Dobbs overruled them. It does not follow from Dobbs that all our substantive due process cases conflict with Glucksberg, much less that stare decisis would counsel overruling any that do. No party to this dispute questions the continued validity of Meyer, Pierce, or Parham. For all its concerns about deciding the issue in this posture, the dissent expresses no doubt that parents have rights, even though unenumerated, concerning their children and the life choices they make. And the precedent recognizing those rights controls our assessment of whether the parents are likely to succeed on the merits. The word likely is important because it reflects that our assessment is preliminary. We consider the merits not to conclusively resolve them, but because they bear on the limited question before us. Are the parents entitled to the benefit of the judgment entered by the district court while California tries to overturn that judgment on appeal? The Ninth Circuit, itself acting on an interim basis, said no. We disagree. The parents must continue to litigate in the Ninth Circuit and, if necessary, this court. But in the meantime, the injunction of California's policy, which incidentally was entered after a full merits process, retains in place. And contrary to the dissent's charge, granting interim relief is not a sign of the court's impatience to reach the merits. Instead, the grant reflects the court's judgment about the risk of irreparable harm to the parents. If the parents were probably right but would suffer little harm from the Ninth Circuit's stay, they would not be entitled to interim relief. But that is not the situation here. Under California's policy, parents will be excluded, perhaps for years, from participating in consequential decisions about their child's mental health and well-being. Thus, the parents are likely to suffer irreparable harm if California enforces its policy while this litigation winds its way through the courts. One last point. The court has chosen to accompany today's order with a per curiam opinion that explains its reasoning. The choice to say more rather than less is perhaps the source of the dissent's concern that our disposition of this application will be taken as a conclusive merits judgment. Interim applications routinely require the court to balance the lock-in risk of saying too much against the transparency cost of saying too little. In my judgment, the benefits of explanation win out here. The Ninth Circuit, following the Sixth Circuit, significantly misunderstood Mahmoud versus Taylor, and general course correction will allow the case to progress efficiently. And because of the Dobbs point that Justice Kagan raises, it would have been unwise to issue an unreasoned order on the parent's substantive due process claim. When an interim application comes to us, we must decide it, grant or deny. Because the Niken factors strongly favor the parents, I see no basis for denying this application. Justice Kagan, with whom Justice Jackson joins, dissenting. Today's decision shows, not for the first time, how our emergency docket can malfunction. A case raising novel legal questions and arousing strong views comes to this court via an application about whether to stay a district court's injunction pending appeal. The ordinary appellate process has barely started. Only a district court has ruled on the case's merits. The court receives scant and frankly inadequate briefing about the legal issues in dispute. It does not hold oral argument or deliberate in conference as regular procedures dictate. It considers the request on a short fuse, a matter of weeks, and then the court grants relief by means of a terse, tonally dismissive ruling designed to conclusively resolve the dispute. The court does all this even though the application of existing law to the case raises tricky questions and so cries out for reflection and explanation. The court is impatient, it already knows what it thinks and insists on getting everything over quickly. Indeed, the precipitousness of the court's decision today has yet a further and wholly new dimension. In granting emergency relief, the court cannot even wait for an appellate court to conclude its own process for deciding the identical issue. As the court notes, a Ninth Circuit panel last month stayed the district court's injunction against the challenged policies pending the state's appeal of that order. The plaintiffs responded by simultaneously filing two motions, one asking this court to vacate the panel's stay and the other asking the Ninth Circuit to do the same thing through en banc review. The Ninth Circuit is already acting on the motion filed there. The court promptly called for and has now received a response from the state, preparatory to exchanging memoranda and voting on reconsideration of the panel's decision. Regular order counsels that in this situation, the Ninth Circuit should go first. The lower court, that is, should decide whether to vacate the stay, and only then should this court decide whether further action is needed. But the court's impatience cannot be contained for even that long. The court jumps the line, preempting the Ninth Circuit's normal and notably reflective en banc process. Why wait for appellate procedures to play out when the court already knows what it wants? And still, there is worse. The court resolves the issues raised through shortcut procedures on the emergency docket, even though it has had, for months now, the option of doing so the regular way on our merits docket. Since November of last year, a petition for certiorari has been pending in a case that, in critical respects, is a carbon copy of this one. In Foote v. Ludlow School Committee, as here, a public school adopted a policy conforming to a state agency's guidance about students who identify as transgender. There, as here, the policy requires school employees to use only a student's preferred name and pronouns, while barring employees from disclosing the student's at-school gender identity to parents. And there, as here, parents challenge that policy as a violation of their right to substantive due process. Footnote 1. The one difference between this case and Foote is that this case also involves a First Amendment free exercise claim, which would, if successful, give relief to parents with religious objections to the state's policy. But as addressed later, the court's recognition of the substantive due process claim here makes the free exercise claim immaterial. That is because accepting the due process claim gives relief to all objecting parents, religious and non-religious alike. So granting certiorari in Foote would allow the court to consider on its regular merits docket the only claim doing actual work here. And if it is nonetheless thought important to address the First Amendment issue as well, the court could grant certiorari, as I next explain, on one of multiple other cases raising both issues that are likely to reach us in short order. Carrying on. Why not then just grant certiorari in Foote and decide it this coming fall? Or if there is some reason that Foote is not suitable, the court could take one of the many cases lined up behind it. By recent count, almost 40 cases raising due process and/or free exercise objections to similar school policies are currently in the judicial system, with several recently decided by appellate courts, so this court would not have to wait long. By granting certiorari on one or more of those cases, the court could ensure that the issues raised by such policies receive the careful, disciplined consideration they merit rather than the inevitably truncated review the court affords emergency applications. Certainly, the court cannot claim that thought and care are not needed. If nothing else, this court owes it to a sovereign state to avoid throwing over its policies in a slapdash way if the court cannot provide normal procedures. And throwing over a state's policy is what the court does today. To be sure, the court sprinkles the word likely atop its assessment of which party's arguments will succeed, but no one, in particular, neither a state official nor a lower court, is apt to read the court's per curiam, brusque though it is, as anything less than a conclusive merits judgment. In any event, there is something else. This case presents some thorny legal issues. The court grants relief to parents on the same two substantive grounds that supported the district court's injunction. First, the court says some parents can show that the state's policy substantially interferes with their First Amendment right to guide the religious development of their children. Here, the court analogizes to Mahmoud v. Taylor, a decision issued last term about school curriculum. The ink on that decision is barely dry, and courts have just begun to consider its meaning and reach. But even assume the court is right on the free exercise score. Still, that could not justify extending relief to all the parents here. After all, some of those parents object to the state's policy not for religious reasons, but simply because it prevents them from taking part in their children's most crucial life decisions. So the district court also ruled on substantive due process grounds, finding a parental right to direct the upbringing and medical care of their children. And indeed, in doing so, the court made its free exercise ruling superfluous, because the due process ground protects every parent, whether or not religious. This court, to affirm the relief given, must follow the same course. It explains that the state's policy excludes parents from participation in decisions regarding their children's mental health, but the very phrasing the court uses betrays the delicateness of the operation. Even in recognizing that parental right, the court cannot quite bring itself to name the legal doctrine. It is again substantive due process that provides the right's only basis. Anyone remotely familiar with recent debates in constitutional law will understand why substantive due process has not been of late in the good graces of this court, and especially of the members of today's majority. The Due Process Clause, needless to say, does not expressly grant parental rights of any kind. The relevant text bars a state only from depriving a person of liberty without due process of law. Members of the majority often have expressed skepticism, sometimes outright hostility, to understanding the capacious term liberty to enshrine specific rights. Substantive due process, one has stated, is a particularly dangerous legal fiction because it invites judges to roam at large in the constitutional field guided only by their personal views. Footnote 2. For that reason, Justice Thomas has called for overruling all of this court's substantive due process precedents. That invitation presumably extends to the precedents supporting both the district court's decision and today's per curiam. Carrying on. Another has pointed to the judicial misuse of the so-called substantive component of due process to dictate policy on matters that belong to the people to decide. And yet a third, when defending the court's elimination of a 50-year-old right grounded in substantive due process, explained that the Constitution does not grant the 9 unelected members of this court the unilateral authority to rewrite the Constitution. There are many such statements to choose from in this court's recent substantive due process case law. Especially given the court's last venture into the field, today's decision cannot but induce a strong sense of whiplash. Footnote 3. Another contrast, this time between this case and United States v. Skermeti, is also striking. In Skermeti, several parents challenged Tennessee's ban on gender-affirming care for minors. The suit raised claims grounded in both equal protection and substantive due process. As to the latter, the parents in Skermeti, similarly to the parents here, asserted a right to make decisions concerning medical care for their minor children. And in support of that right, the Skermeti parents relied on the same precedents the court does today, Parham and Pierce. But the court, when deciding to grant certiorari in Skermeti, limited its review to the equal protection issue. It would not even hear the parents out on their substantive due process claim. Carrying on. None of this is to say that the court gets the merits here wrong. It may not, as to the plaintiff's free exercise claim or their substantive due process claim, or both. As to due process particularly, because again, that claim alone does all the load-bearing work in this case, I have no doubt that parents have rights, even though unenumerated, concerning their children and the life choices they make. On the other side of the ledger, of course, a state has critical interests in the care and education of children, but California's policy in depriving all parents of information critical to their children's health and well-being could have crossed the constitutional line, and that would entitle the parents at the end of the day to relief. The court, however, would be far better equipped to draw the appropriate line and explain its legal basis, in short, to do law the right way, if it had followed our ordinary processes. A mere decade ago, this court would never have granted relief in this posture. Indeed, I am confident that the plaintiffs would never have thought to ask at this stage for the court's involvement. Then, though apparently not now, we understood that our normal processes, full briefing, oral argument, conference, and opinion writing, along with the time they take, exist for a reason. They ensure that before the court makes a decision, it has marshaled all the relevant facts, considered all interested parties and multiple lower courts' legal arguments, and deliberated internally with full understanding of each other's perspectives on all disputed issues. So too, those processes enable us to think through the best legal rationale for and scope of any decision given both the views we have earlier expressed and the related issues that will soon come before us, and they allow us to explain ourselves well and carefully both to the parties and to the public. Our processes are, in short, the hallmark of judicial probity, and alike its guarantor. There was no reason to abandon them here. I respectfully dissent. And that does it for the opinions in this case. As you probably gathered, but I feel I should point out anyway, this is not a decision on the merits of this case. This is a preliminary decision on the emergency docket, or so-called shadow docket. The court is just vacating the Ninth Circuit's stay of a district court injunction against California's policies requiring school employees to not inform parents about gender transitioning and whatnot. And it's honestly kind of weird to see so much written about this. Normally, these sorts of orders don't have a ton written in them. There's not much by way of concurrences or dissents or whatnot. It's just, just the order is handed down and that's kind of it. Like in the whole Virginia redistricting or gerrymandering thing, the state Supreme Court says this constitutional amendment wasn't properly ratified. And so the gerrymandered maps that it enabled, are void or whatever. Virginia comes up to the Supreme Court asking for, an emergency stay of that decision. The Supreme Court said no, and there were no opinions in that, in that shadow docket case. It was just no noted dissents, no concurrences, nothing. So, yeah, kind of weird to see so much written in this one. But anyway, as to what was actually written, so the per curiam, kind of just goes through the factors for a stay and says the Ninth Circuit's stay of the injunction was not justified here. The parents are likely to succeed on the merits. They will suffer irreparable harm. The balance of the equities is in their favor, so no, we're vacating the Ninth Circuit's stay. And then Justice Thomas and Alito would have vacated the stay as to the parents and the teachers, everybody in full. Sotomayor would have denied the application. And then you get to the concurrence and the dissent, which is really where most of the back and forth is going on. The concurrence on behalf of Barrett, joined by Roberts and Kavanaugh, says, the dissent, Kagan and Jackson criticize us for saying too much in this case, but in previous emergency docket cases, Justice Kagan has criticized us for saying too little, for handing down these unreasoned opinions on the shadow docket. So, sometimes you should say more, sometimes you should say less. In this case, the court decided we should say more, and in other cases, Justice Kagan has chided us for not saying more. So, like, that criticism, the concurrence says, kind of falls flat, and then the concurrence moves on to another criticism that, Kagan says the majority is being, hypocritical as to the substantive due process issue, because, many conservatives, conservative jurists and legal scholars and conservatives on the court have, in my opinion, rightly criticized the substantive due process doctrine. And, the concurrence says, well, in Dobbs, which is like the prominent case that Kagan is citing here for the proposition that the conservative justices on the court are not very friendly to substantive due process. The concurrence says, well, in Dobbs, we didn't close the door on substantive due process. We didn't say substantive due process is a nonsense made-up doctrine that we're not applying anymore. In Dobbs, we said substantive due process doesn't support a right to abortion, that the standard for determining what unenumerated rights are protected in the due process clause of the 14th Amendment do not support a right to an abortion. And then the concurrence doesn't address another of the dissent's criticisms, which is just like the procedural sort of posture of this, or at least I don't think it addresses it at length. Kagan says the court took this up before the Ninth Circuit even had a chance to opine on it. There's an application before the Ninth Circuit right now, and the court, sort of snatched it in its quote-unquote impatience. Kagan kind of criticizes the court for, taking this up because it, knew what it wanted, and the court is she accuses the court of, or at least the majority of, deciding this issue on the emergency docket, essentially on the merits without saying they're deciding it on the merits, sort of cloaked in a preliminary garb. But, she says the court knows what it wants. It wants to decide this issue on the merits in a way that would favor the parents here. And I don't know, I feel that's a little unfair. I mean, maybe the court rushed things, I don't know. I don't really care much for these like procedural criticisms, like, oh, the court took this too fast, it shouldn't have addressed this on the emergency docket. Like, I don't know, if it was an issue of like the court didn't have jurisdiction or something, that would be another, that would be a whole other issue. But like, oh, you didn't give the lower courts enough time to think about this. You didn't give the lower courts enough time to address this by themselves. I hate the Roberts Court's like fetish for percolation in the lower courts. So if the Supreme Court wants to act a little more quickly and snatch things out of the hands of lower courts a little bit more, I'm really not all that concerned with that. So yeah, that doesn't hold a whole lot of water with me. And the idea that like, oh, the court is effectively deciding this on the merits, it knows how it's going to decide, and so it's basically deciding this on the merits on the emergency docket without saying so. I feel like that's kind of unfair. Like, likelihood of success on the merits is one of the factors for a stay. And yes, usually a court that says this party is likely to succeed on the merits in a preliminary order, when this comes back around, for a full merits decision, that same court is likely to say, yep, you succeed on the merits. That's kind of the whole point. that's the thing. That's the standard. It's likelihood of success on the merits. So yeah, usually the same court will find, oh yeah, you succeed on the merits. I don't know. This is, again, that criticism also doesn't really hold a whole lot of water to me. Yeah, and then to circle back around to the substantive due process issue, I don't like the substantive due process like doctrine or whatever. I think it is frankly made up bullshit. And it does present all the dangers that, conservative jurists and justices on the court and whatnot have pointed out, that, it's kind of just this open-ended invitation for judges to insert their own values into the Constitution. It's very easy to, read rights into the Constitution, read constitutional rights into the Constitution that are not there, like, for example, a right to an abortion. Of course, the Constitution does protect unenumerated rights. It says as much in the Ninth Amendment, and I would argue in the Privileges or Immunities Clause of the 14th Amendment. But the Supreme Court has gutted this Privileges or Immunities Clause of the 14th Amendment, and the Ninth Amendment has not been incorporated against the states. So I feel like the substantive due process kind of doctrine was sort of built up to get around that, to protect enumerated constitutional rights and unenumerated constitutional rights against encroachment by the states. So yeah, I don't like the substantive due process doctrine, and I kind of agree with Kagan a little bit. To see justices that have been very, very vocal critics of the substantive due process doctrine, like Thomas and Gorsuch, not say anything about it here and just kind of go along with the substantive due process analysis to decide in favor of the parents here. Yeah, I'm not a huge fan of that. I think Justice Kagan takes this accusation of hypocrisy a lot further than it actually goes, to say, to include like, Kavanaugh and, basically the entire majority, when the entire majority is not necessarily down with upending the court's substantive due process jurisprudence. Like, you've got the concurrence saying, no, that's not what Dobbs said. That's not what we said. We're cool with substantive due process. It's just a right to an abortion is not, does not sort of satisfy the standard for finding an unenumerated right in the due process clause of the 14th Amendment. However, a right to make decisions about your child's health and mental health and whatnot, like, that is there. So, hence the different outcome here. Again, a little disturbed that like Thomas and Gorsuch aren't saying anything, and they're just kind of like going along with that because, they are a little bit different. Thomas in particular is like, no, all the substantive due process stuff has to go. He's been a, long-standing critic of the substantive due process doctrine. Kagan cites one of his concurrences, McDonald versus Chicago, where he says, no, the Second Amendment is not incorporated against the states by the due process clause of the 14th Amendment. It's the Privileges or Immunities Clause of the 14th Amendment. And I think he's right there, but then he doesn't say anything like that here. He could, for example, say, oh, hey, by the way, substantive due process is still made up bullshit. The parental rights stuff comes from the Privileges or Immunities Clause. I concur in the judgment, right? Like, but he's not saying that here. And I don't know, maybe they're just not saying things because it's an emergency docket case, and it's weird to have justices saying very much in emergency docket cases. I don't know. But yeah, as to whether the parents should get the stay in this case, or should get vacatur of the stay in this case, I'm honestly not too sure. I would tend to think yes. I mean, if the Constitution is protecting unenumerated rights, which it says that it is, I would think, the right to raise your children as you see fit would have to be in there. And if the state is encroaching on that by saying, oh, you schools, you have to interfere with parents raising their children as they see fit, that presents a bit of a problem for that enumerated right. So on the merits, yeah, the parents might be likely to succeed. Although, again, I don't think based on the substantive due process clause of the 14th Amendment, I think that's based on other constitutional provisions, but still, yes. The free exercise claim, again, I kind of agree with Kagan, like, that seems to be swallowed by the substantive due process part, or the parental rights part. I mean, not to say that that's not worth addressing, but I don't know. I guess as a practical matter here, does it really matter? But yeah, I mean, on its merits, I don't know, maybe. I I mean, I think there's at least a colorable argument that yeah, the free exercise claim has some merit here, especially in the face of or in the wake of other precedents like Mahmoud. But it does just feel a little bit more like a stretch than hey, we have an unenumerated constitutional right to raise our children as we see fit. The states are interfering with that. But that's a little bit vibes based, I guess. I don't know a ton about free exercise like jurisprudence and original meaning and all that fun stuff, so anyway, all that said, if I may ask you, my friends on the other side of the screen, please like, share, comment, follow the podcast wherever you follow podcasts, and if you would like to support it, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members have access to bonus and exclusive content, and they can request specific content, including other than reading Supreme Court opinions. With that, tune in for the next episode where we will continue through the Supreme Court's 2025 term. Until then.